All right. It looks like we are live. What is going on this Thursday, BRI-HIVE? If you are new here, go ahead and drop a 1 in the chat. And if you're watching on the replay, drop a 1 in the comment section. For those of you who do not know me, I am Boss Attorney Bri. And here on this channel, we cover trademark lawsuits, copyright lawsuits, celebrity lawsuits, and really whatever we feel like covering. In the real life, I am a California licensed attorney where I practice family law and trademark law. And if you have been on my channel before, or you were here this past Tuesday, you know that I also have a trial coming up tomorrow. So I'm hoping that this live stream will not be that long, but these were some pretty good cases that I did not want to pass up today. So go ahead and let me know where you guys are watching from, and we're going to just jump right into it. Normally we do like a little icebreaker, or I'm trying to implement normally doing an icebreaker, but today we just don't have time to do it. So we're going to jump right into it. Now, we have been covering a lot of trademark, a lot of celebrity defamation, a lot of other celebrity cases, but today we are taking it back to copyright, kind of similar to the case that we covered with Mariah Carey and the copyright of All I Want for Christmas. But this one sounds a little bit more similar to me than the Mariah Carey situation. So I think we're going to try to actually listen to the similarities, and you guys can let me know whether you think it sounds the same or not. So who are we talking about today? Who's getting sued today? There are 2 different people being sued today that we're going to cover. The first one that we're going to cover is Megan Thee Stallion and Big Sean, but we're going to focus on Megan Thee Stallion because she's the one bringing in the headlines right now. And they're being sued for a song called Go Crazy. When I first read the article, I thought I confused it with like the Chris Brown song Go Crazy. I'm like, oh, they didn't get the right sampling contract signed. Oh, that sucks. But then I realized once I played the song, it was a completely different song that I had never heard before. So obviously I am not up with the times, okay? So Megan Thee Stallion is being sued for copyright infringement. And then we have our good girl, Kim Kardashian, actually responding to the crypto lawsuit that was filed against her back in January, along with some other celebrities like Floyd Mayweather. And is Jake Paul in this one? I think Jake Paul is in this one too. I can't remember all the way right now, but she has responded to this case saying that it should basically be dismissed. Most of the time, that's the way that cases go. You're either going to answer or you're going to move to dismiss. They chose to move to dismiss. Now, there's another defendant in this case that also chose to move to dismiss, but I don't even know who that person is. So we're going to cover the Kim Kardashian one. The other one was shorter, but the Kim Kardashian one is the one that we're interested in. All right, so who do we have here in the chat? We have Tanya D saying, good evening, everyone, and that she'll be back after the meeting. Okay, well, welcome, and thank you for joining the live stream, guys. Go ahead and drop in the chat where you're watching from. If you're watching live or you're watching on the replay, go ahead and hit the thumbs up button to help us out in the algorithm. And like I said, we're going to jump right into it. So we have our girl, Megan Thee Stallion. Let's look at the complaint first, and then we'll go into whether the songs sound the same. And guys, this is a live reaction for me because I have not had time to look at it fully. I literally just downloaded the complaint. So we're going to be reacting to this live together. So I did not share my screen yet. So let me get that part together. Sharing the screen. My voice is already tired. I should probably be saving my voice for tomorrow, but that's okay. We have Kath here watching live saying hello, hi, welcome to the live stream. We're going to get right into the case. All right, I shared my screen. Now I got to reshare it. Okay, let's make this bigger for the peeps to see in the back. All right, so we have Dwan Payne and Harold James. They're suing Theory Entertainment. They're suing Certified Entertainment, Universal Music Publishing, Sean Mitchell, Leonard Anderson, which I'm guessing is Big Sean. Yep, that's Big Sean. And Megan Ruth Pete, which is Meg Thee Stallion. So they are suing them in the Southern District of New York. Yep, New York, if I remember correctly. And then here we have the substance of the action. This is a case of willful copyright infringement in violation of 17 USC. Plaintiff seeks damages and the amount to be established at trial. So they're not really telling us exactly how much they're requesting, but they are requesting money in this case. So let's see, we have the parties. We're going to skip over that. We want to get into the meat and potatoes of this case and see what is actually going on. We don't care if they have any jurisdiction, right? All right. So before we get into the meat and potatoes, let's check out the comment section. We have Tiny D saying, make sure you do the YouTube things and hit the like button, subscribe button on your way in. Yes, guys, if you are not subscribed yet, go ahead and hit the subscribe button. And if you have not hit the thumbs up yet, go ahead and hit the thumbs up button and help us out in the algorithm so we can get new friends, so more people to subscribe, right? We have Myra saying that she's ready. Well, I'm ready too. This is going to be a shock for me. Amanda says, well, yay. If it's in New York, now no, we can pull up all the documents from the website we were playing with on Tuesday. This one is actually a federal case, so I have a way to pull up those through Pacer. It's a lot easier than trying to go state by state. All of the states, district courts are not district courts. Yeah, the district courts are on that website, so it's a lot easier to pull up. Not as frustrating in New York. And I actually got an email this morning that I didn't complete the account from that New York website, so I'm going to have to finish that one up. So yeah, this one is from Pacer for sure. Okay, let's check out what's going on in the facts of this. And then we're going to actually listen to the songs and let me know, one, if you guys have heard the songs before. I had never heard of it, so maybe I'm just not hip. But I had never heard of the song. And then let me know if they sound similar. I haven't listened to the whole song. We're not going to listen to the whole song on the live because we don't want any, copyright strikes or anything like that. But we're going to comment on it and see whether we think it sounds similar or not. So we have plaintiff's copyrights. In 2012, plaintiff authored the song Crazy and have publicly and widely distributed the copyrighted work in numerous ways. And then they're going to tell us how they've done it. For examples, plaintiff have distributed the copyrighted work through the music platform Reverb Nation, where the copyright work has been available to more than 2.8 million artists and consumers worldwide, and record labels and managers had access to the song. In 2015, the copyrighted work was ranked number 1 in Detroit. In addition, plaintiffs distributed thousands of copies of the copyrighted work in CD format in the greater Detroit area. Moreover, beginning in 2012, plaintiff publicly performed the copyrighted work in numerous clubs in the Detroit area. The copyrighted work continues to be available on Reverb Nation. The copyrighted work is an original work of authorship. The chorus of the copyright work is highly artistic and original. I don't know if they're going to be able to prove that part because saying go crazy. We'll see when we listen to it. On February 14, 2022, plaintiff obtained a certificate of registration for the copyrighted work in the United States Copyright Office. So they waited 10 years before actually getting the copyrighted work registered, even though with copyrights, basically as soon as you put it into your tangible medium, you're copyright protected. But it's the same thing, or not the same thing, but it's similar to trademarks in which, yes, you get it as soon as you start using it or as soon as you make it. However, it's a lot harder to prove. It's a lot harder to put out there and say people knew about it because you don't actually have it registered. So yes, they probably do own the copyright because they made the song, and their particular song is going to be a question of whether Megan Thee Stallion song is similar enough to them that it should be considered copyright infringement. And they're saying it's intentional, that they knew of the song. So let's see. Defendant's unlawful activities. On November 20th, 2020, the defendant, Pete, 300 Entertainment and 1501 released the album Good News. The album Good News contains a hit song called Go Crazy. Go Crazy is referred to herein as infringing work because it is unlawful derivative of the copyrighted work, infringing both the composition rights and sound recording rights of the copyrighted work. The infringing work was created by Pete, which is Megan Thee Stallion, and others, including Anderson, who is featured on the infringing work, which is Big Sean. The infringing work is strikingly similar to the copyrighted work. I will let the chat be the judge of that. The titles of the infringing work and copyrighted work are strikingly similar. The chorus of the two songs are similar. The wording of the chorus of the two songs are nearly identical. The timing is nearly identical. The melodic sequence is nearly identical. The harmonic sequence is nearly identical. Tonal sequence, the reverb is nearly identical. The cadence, an average lay observer would recognize the infringing work as having been appropriated from the copyrighted work because of the striking similarities between the two compositions. So they're basically alleging everything is similar. So not just the words here, which to me, after listening to a brief snippet of it, I do think it's a little more similar than when we covered that Mariah Carey case where we're like, oh, I do not hear it. I don't hear it. I don't hear it. Not only the Mariah Carey case, they waited 20 years to bring it. But these people, I don't think they said when Megan Thee Stallion, or did they say they released it on the album in 2020? So they waited 2 years to bring it after getting their copyright actually registered. But they're saying a lot of components of the song are similar. So to me, they would have more of a chance than the person suing Mariah Carey had. Okay, so indeed, the infringing work is so striking similar to the copyrighted work as to preclude the possibility of independent creation. Basically, don't think they could have come up with it on their own. Plaintiffs' wide dissemination of the copyrighted work has made it readily available on the market. The dissemination of the music in the music industry has changed drastically in the last 2 decades as consumers no longer access their music through radio stations and record stores, as they instead access music through their computers and smartphones, where music is readily available on platforms like YouTube and Reverb Nation. Prior to the creation of the infringing work, the copyrighted work was available on both YouTube and Reverb Nation. In addition to availability on the internet platform, plaintiff distributed thousands of physical copies of CDs. Further, prior to the creation of the infringing work, plaintiffs performed work publicly. Oh, you guys are just looking at me. Look to the side. Sorry. They performed work publicly in clubs and bars. In addition, defendants each had access to the copyrighted work through Anderson. So now he is basically alleging, or they are basically alleging, that Big Sean had a copy of the work or a copy of the song, right? So if this is true, I think they have a way, way, way better claim than the people suing Mariah Carey. Let's see what the peeps are saying. Amanda says, yeah, us nosy people can create Pacers account too. I have one. Yep. It's completely free. Unless you spend more than $30 in a quarter, then they don't charge you. But if you spend more than $30, like downloading all of these documents like I do, then it's going to cost you the monies. Amanda says to Tanya, I was telling my former branch manager, who is licensed investment banker, about the foolery in the case on Tuesday. He was like, no way. I think it says shout out is looking at federal penalties if it happens again. I don't know what the SO stands for. I'm going shout out. Probably not what it stands for. All right. So here we have, okay, they're saying that Big Sean had access to the document. Where did it go? Prior to the creation of the infringing work, Anderson and plaintiff resided in West Detroit, where the copyrighted work was publicly performed by plaintiffs in West Detroit hip-hop clubs and bars frequented by Anderson. So basically saying that Big Sean went to the clubs that they would perform at. Anderson had further access to the copyrighted work, given the copyrighted work #1 ranking on Detroit's charts at Reverb Nation in 2015. The sale of thousands of physical copies of CDs featuring the copyrighted work on the street of West Detroit and the parking lots of hip-hop clubs in West Detroit frequented by Anderson provide further access of the copyrighted work to defendants. But how do they know if he was there on the days that they actually performed? I don't know if I'm buying that one. If he would have said, oh, we handed him a CD, then yeah, sure. But, oh, he used to go to those clubs and we used to play at those clubs, so he must have had it. I don't know if I'm going for that one all the way. Okay. Due to the striking similarities between the infringing work and the copyrighted work, the wide dissemination of the copyrighted work, and the access of the copyrighted work by Big Sean, defendants each had a reasonable opportunity to hear plaintiff's copyrighted work prior to the creation of the infringing work. In addition to striking similarities, there are substantial similarities between the copyrighted work and the infringing work. Defendants have copied music and lyrics, which taken together are highly original and engaging. Indeed, defendants are reproducing, distributing, publicly displaying, and or publicly performing the very heart of the copyrighted work, its chorus and hook. The originality, uniqueness, and catchiness of the copied element is such that an ordinary person of reasonable attentiveness would, upon listening to both, conclude that defendants have unlawfully appropriated plaintiff's protectable expression. Megan Thee Stallion, together with 300 Entertainment, 1501 caused the public release of the infringing work and have since caused the infringing work to be widely reproduced, distributed, performed, licensed, displayed, marketed, promoted, and exploited, deriving substantial revenue and profits of the infringing work. Well, this song came out in 2020 and I never heard it, but not to say I'm the big hip hop girl or anything like that, but I had never heard it. And them distributing it in Detroit mostly, that may go against them. I understand that they're using that to establish that Big Sean probably most likely heard the song, but it doesn't sound good for them, in my opinion, that okay, only Detroit people knew of the song. So for wide dissemination, I don't know if they're completely reaching that what do you call it? Reaching that factor. Okay. Defendants' reproduction, distribution, public display, sale, all of the things on the work are without plaintiff's authorization. Upon release of the infringing work, sold reportedly 100,500 units in the first week of the release. Since the debut, the infringing work has reportedly gone platinum, meaning more than 1 million copies have been sold. Okay, Megan Thee Stallion. In addition to the success in streaming and sales, the infringing work has also been exploited by defendants via other means, such as via live performance and via audio-visual synchronization and licensing. Okay, what's going on? The amount of ticket sales and revenue derived from the live performance and licensing of the infringing work are not known to plaintiff at this time. On March 31st, 2022, plaintiff caused a letter to be sent. They are using so many words just to say something so simple. They sent a letter to the defendants in order to put the defendants on formal notice of plaintiff's objection to the defendant's unauthorized and infringing reproduction, publication, promotion, distribution, license, public display, public performance, sale, and all the things of the copyrighted work. The letter also, in good faith, sought to amicably resolve the issue of defendants' continuing infringement in an effort to avoid the need for plaintiffs to seek assistance from the court to enforce their lawful rights afforded by Congress under the Copyright Act. Since being placed on notice of their infringing conduct, defendants have continued their willful and reckless disregard of the exclusive copyright belonging to plaintiff, forcing plaintiff to initiate the lawsuit. What do you guys think so far? They're alleging that a lot of it sounds the same. So they're basically suing for direct copyright infringement because they're claiming that Big Sean knew about the song. Katzen have known about the song. Come on. Here we go. All right. They're also doing contributory copyright infringement by the defendants. Basically, if they weren't the one that made the song, they contributed to the song being made. They are suing for vicarious copyright infringement. So through Big Sean, probably who they're alleging, they also copyright infringe. And then they are asking for all of these things in the jury, and they want a jury for this case. What do you guys think so far? We're about to go over and listen to the song. Our good girl, Megan Thee Stallion, is being sued in this case. So who is ready to hear the song? Go ahead and drop a 1 in the chat if you guys are ready to hear the song. And then drop a in the chat if you want to hear this not anonymous, but the smaller creator, if you want to hear that song first. or drop a beat in the chat if you want to hear the Megan Thee Stallion song first. We have Amanda saying, oh, SO means someone. When I'm writing in shorthand, sorry, I have a weird abbreviation. No, it's okay. That definitely makes sense now that I'm thinking of it. Now that I see it, I probably will remember it as that. So it doesn't look like anyone really have a preference about the song. Okay, Myra said 1A, so I forgot what 1 was. I forgot what 1 was already, so that's okay. Okay, we're gonna listen to the smaller creator song first to see what you guys think about it. I really was not familiar with the Megan Thee Stallion song, which really shocked me. So let me see what Amanda says. Amanda says, how would they be able to say just because someone contributed they are liable? Have they been in the recording studio? They do that. It's bits and pieces and out of order. So I'm assuming that they're saying if Megan Thee Stallion is not directly liable for copyright infringement, she's vicariously liable. And so all the people that they're actually suing are like the recording artists and the producers of the song, the labels that own the song. So they could be pulled in for the vicarious, but they can't just like come sue me and say you're vicariously liable. I would have to have some type of connection to them to put the song out. So she also said 1A. It was like, never mind. Yeah, I completely forgot what 1 means, but I know A means for the new artist to be played. So let's see, and let's hopefully YouTube doesn't get at us crazy. So we're not going to be able to listen to it for a long time so that we can at least just compare. So go ahead and listen to the beats on this. The words, they're saying that the words are similar to. Like I said, I didn't have time to go over this before we popped up on a live stream today. And so I thought they were going to put like more of the wording in the actual complaint, but they didn't. So let's see what they have to say. So this is from the smaller creator who is claiming copyright infringement against the big artist. So let's see. Can y'all hear that? Let me know in the chat if you guys can hear that. And then I'm going to continue to play it. So let's see. A lot of cousin. Okay, so. All right. Okay, so I paused it at 20 seconds. So let's see what's going on with Megan Thee Stallion. Can you guys, you guys can barely hear it? I don't know how to make it. How do you make it hear it? Do I need to put my microphone up to it? I feel like that's gonna sound weird. Okay, let me try it again. Can I rewind this song? No. Can y'all hear it? Flexing and relaxing in this bitch going crazy. Girl, I'm about to go crazy and fuck the club up. Girl, you should go crazy and fuck the club up, cause we about to go crazy. Go crazy. Go, girl. Was that better? I don't know. I don't know how to make the volume good on this. Let's see. Audio. This is my audio. Yeah, I don't know. Could you guys hear it? Oh, Cass said the volume was down. That was better though. Okay, that was better. Okay, I'll put the mic up to it. I'm trying to figure out how to hear the volumes when I'm on the live stream. Okay, so that was the first song. So it had a lot of little snares and all the things in it. But let's see about Megan Thee Stallion song. So here we go. Yeah. Real hot girl shit. Okay, the hate turned me to a monster, so I guess I'm evil now. Woke up and I blacked out everything so I can see it now. I'm on that demon time, it's only right I cop the Hellcat. Okay, so just starting off the song, she doesn't start off with the chorus, so let me see if I can find the chorus to see. if she gets similar to them.
Body isn't everything they find, and that's all. Nigga didn't shoot me and they picking sides. I'm about to go crazy. I ain't pulling up, let them hoes finna pay me. Bitch, I'm the shit, and I ain't gotta prove it. Finna go dumb since these hoes think I'm stupid. I'm about to go crazy, 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 crazy. I'm about to go crazy, 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 crazy. Bitch, I'm about to go.
I hit one.
That was kind of the same rhythm. I didn't even hear that part when I first looked up the song. Were you guys able to hear that similarity? Because that was pretty, let me see. Yeah, it's the same rhythm.
Girl, I'm about to go crazy. Fuck the club up, girl, you should go crazy. Fuck the club up, cause you about to go crazy.
Yeah, I don't know, Big Sean. I don't know, Big Sean. You might have heard this in Detroit. Yeah. Okay. We got Mr. CKB. Welcome back to the live stream saying, did I miss anything? Yeah, you missed the whole complaint. We went through all the facts in the complaint. And this is just a copyright lawsuit of Megan Thee Stallion being sued by a smaller creator for this song, Go Crazy. I didn't listen to the chorus before we got on here, but I thought that the beat sounded similar. But now I've listened to the chorus and it's literally the same rhythm. And so usually I would say, oh, something like saying go crazy is not very unique because like I said, when I first read the article, the first song that popped in my head, I don't even think Megan Thee Stallion is on the song, was Chris Brown's Go Crazy. That samples a different song. But this is a completely different song. So I was thinking, go crazy. That's a common saying in a song. But listening to this, no. I think that they're on to something here as far as copyright infringement going. Definitely, to me, a way better case than the Mariah Carey case that we looked into. All right. We have Rebecca H saying, they're awfully close. I agree with you there. I think that they are close. We have a Lick L saying, hey, Boss Bri, hello, and welcome to the live stream. Nice to see you here. Mr. CKB says, oh no, I guess I got to catch that beginning on the replay, but I'll catch up. I'm tuned in now. Okay, so I don't know if we have any like super into music people here in the live stream, but let me know if you are, because I'm not good at listening to like the tones and the melodies and things like this, but I think they are on the right track of saying that this is probably copyright infringement. If they can show that this was widely disseminated and the defendants likely had access to the song, I think they are on track to get some money. To get some money out of this case. So I'm gonna play it one more time for those of you that might have popped out or popped over to see if you guys can hear it all the way. So we're gonna play the what is this? This is a smaller creator, the people that's suing Megan Thee Stallion and Big Sean. And let's see.
Girl, I'm about to go crazy and fuck the club up.
A lot of cussing.
Go crazy, fuck the club up, cause we about to go crazy. Go crazy, go girl, you dancing in the club like you the only girl in this bitch. Walk up in the club to the keyboard.
All right, they walked up in the club, and then we'll go to Megan Thee Stallion. Let's see.
And that zone, nigga didn't shoot me and they picking sides. I'm about to go crazy. I ain't pulling up, let them hoes finna pay me. Bitch, I'm the shit, and I ain't gotta prove it. Finna go dumb since these hoes think I'm stupid. I'm about to go crazy, 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 crazy. I'm about to go crazy, 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 crazy. Bitch, I'm about to go.
I hit once, I hit twice, now it's a habit. I go cash it. So this nigga made you crazy. This dick make you suck.
I didn't hear the beats are very similar. Like I thought they were similar earlier, but they're very similar. You could probably play these together. I think theirs might be one of them might be a little slower than the other, and maybe that's why they won't line completely up. But I definitely hear the similarities in that. Okay, we have Soul Solid 4 saying music guy here. LOL, yeah, it's close. I hope they cleared that Jackson 5 sample before they say they need money. I didn't even hear a Jackson 5 sample in there. I didn't even hear it. So to me, I think they're on the right track. The beats sound very similar. I'm gonna see if I could get someone to put them on the same track to see if they really sound alike. I hope they don't copyright strike me in anger. Because the last Megan Thee Stallion video I did, I got copyright claimed. Or did I get claimed or strike? I don't know. But they basically took my money from that video. But we're commenting here, so transformative use. We are not infringing. We're not infringing. We're using it for educational purposes and to compare and contrast. And whether we think that this is a good copyright lawsuit, I do think that this is a good copyright lawsuit. Is, like I said earlier, way better than the Mariah Carey one. I think I've covered another one on this channel, and then we've done a couple of picture ones. But this one, I think y'all might want to settle this. They better not move to dismiss this. They might as well give these people their money and go on about their business. And if they get their money, I think they will be very excited because their song has been out since 2012 with no real recognition. And all of a sudden, a big artist puts it out and they get all of this recognition. So we will see what happens there. Cap says it's similar. Yes. Myra says, yeah, it definitely sounds similar. I agree. And Soul Solid Force says it's at the end of the clip. You hear a random singing in the background. Okay, I did hear some singing in the background, but I could not hear what it was. You got some good ears there. Mr. KCB said, if you ask me, it's close. However, it certainly could pass for a remix. You can't just go around remixing people's song without them being on it, though. So that wouldn't be appropriate. They could have probably sampled the song and paid them. The whole thing is they would have had to license the song from them, whether they wanted to do a remix or whether they wanted to be featured on it, whatever it might have been. These songs sound super similar. And like they said, a regular person like me listening to music, I would think that sounds similar. Now, that Mariah Carey case that we covered, I don't know where they was getting that from, just the sign All I Want for Christmas. That's a common saying, okay? But the actual songs, they didn't sound anything alike. This one is a lot more alike than that other case that we covered. So thank you guys for chiming in with your opinions on whether these sound similar. We have one more case to cover today, and that is our good sis, Kim Kardashian. I don't know why I always say that. I'm not a fan of Kim Kardashian at all, so I don't know why I say good sis, Kim Kardashian. I could probably care less. But if you have been following me from like the get-go, but I know a lot of people here are new, I covered a case where Kim Kardashian, along with Floyd Mayweather, along with, I keep saying I believe Jake Paul was also in this case, but I believe Jake Paul was also in this case, were sued for a crypto scam. So they were basically promoting cryptocurrency, telling people that they gained so much money by having this cryptocurrency, and it basically ended up being a pump and dump, and a lot of the regular folks lost their money, and so now they're suing in a class action. There was actually 2 lawsuits filed for the same thing, but they consolidated it. I didn't go through the paperwork for that, but I did see that there were 2 actions going for the same thing, and now it has been consolidated into one case. 2 of the defendants so far has filed a motion to dismiss, and one of those defendants is Kim Kardashian. And Kim Kardashian is always in the news for something, right? First lawsuit, I'm going to say it was her first lawsuit of the year because it was like January 7th or something like that when it was first filed. But who knows? She might have more more lawsuits coming in the beginning of the year than normal people do. Okay. And so it looks like they're going to have a hearing on October 17th to find out whether this is going to be dismissed. And this case was filed in the Central District of California. Let's check out the actual paperwork. Let's see. Boom, boom, boom. Oops, that is too big. I cannot even read that. All right, so let's see. We have in Ethereum mass investor litigation, and this is Kim Kardashian's motion to dismiss. They go ahead and put everybody on notice that they are moving to dismiss for failure to state a claim, otherwise known as Federal Rules of Civil Procedure 12B6, but they're also suing under, or not suing, but moving under 9B. And it's based on a notice of motion and motion accompanying the memorandum of points and authorities and pleadings and evidence on file of this matter. Basically, the defendants request that the court dismiss the claim in the CCAC pursuant to federal rules 9B and 12B6, failure to state a claim. The issues to be decided under this is whether the CCAC should dismiss California Central, what is the CCAC? Whether the court should or whether the complaint, the consolidated complaint amended. The consolidated amended, it was something like that. They consolidated and they also had an amended complaint is basically what I'm trying to say. Okay. Under federal rules 9B and 12B6, due to plaintiff's failure to adequately plead fraud and failure to state a claim against defendants upon which relief may be granted. So basically that they're not liable. A memorandum of points of authority, they're going to give us the relevant background. They're going to give us some legal standards, and then they're going to give us these arguments. They say plaintiffs failed to state a federal RICO claim. We are talking about RICO in the civil court again. So plaintiffs lack statutory standing to sue under RICO. Plaintiffs lack a cognizable property injury based on an expectancy interest in EMAX token value. Plaintiff failed to allege that any racketeering activity proximately caused any alleged injury. Plaintiff failed to plead a plausible RICO claim. Plaintiff failed to allege a RICO enterprise. Maybe I need to go back and read the complaint. I don't know if I saw anything about these RICO claims. But then again, I did cover it back in January and I haven't looked at it yet. So let's see. Plaintiff failed to allege a RICO enterprise. Plaintiff do not plead a common purpose. Plaintiff do not plead an ongoing unit. Plaintiff failed to allege continuity. Plaintiff failed to allege that all defendants conduct the affairs of any alleged enterprise. Plaintiff failed to allege predicate acts. Plaintiff failed to allege pattern of racketeering. Woo, this is going to be a long one. It's 55 pages, her response. Plaintiffs lack standing to assert claims under other states' laws. Plaintiffs failed to allege threshold requirements for the state consumer statutory claims. Plaintiff lacks standing to sue under UCL, CLRA, or FAL because they do not plead actual reliance on alleged misrepresentations or omissions. Plaintiff failed to state FDUTPA, all of the letters, claims because they failed to allege causation. Plaintiff failed to state any state statutory claim because none of the alleged misrepresentations or omissions are actionable. Plaintiffs do not allege misrepresentations likely to mislead reasonable consumers. So they're saying they're not reasonable in relying on this. Plaintiff do not allege any material or otherwise actionable omissions by defendant. Plaintiff failed to state any UCL claim. Plaintiff cannot state a CLRA claim because the EMAX token is not a good or service subject to CLRA. Plaintiff failed to state an aiding and abetting claim. Plaintiff failed to state a common law civil conspiracy claim. Plaintiff failed to state any claim for equitable relief. So a lot of things that they're saying why this action should fail. So let's see what the peeps are saying. Kat says a Kardashian lawsuit again. I don't know why I'm still surprised at this point. Yeah, I think they're going to keep coming. I don't think they're going to stop. And then we have Divinity Said popping in with the hearts. Thank you so much for showing support to the channel, guys. If you have not already, go ahead and hit the like button. If you're not subscribed, go ahead and hit the subscribe button. Help the channel out. Help the BRI-HIVE out. We need some honey over here to feed the bees. I don't know if that made sense, but yeah. Okay, they got a bunch of cases of authorities here. Let's get through this. Let's not make the peeps dizzy today. Ooh, they got a lot of cases in this case. Boom. Okay. Now we finally get to the opening of the complaint, or not the complaint, of the response, and we are 17 pages in. So that's how many cases they are citing in this case. Let's check it out. We have an introduction. This lawsuit is a misguided attempt by plaintiff to extract a monetary windfall from defendants due to plaintiff's decision to purchase a highly speculative, volatile cryptocurrency. The CCAC must be dismissed for at least 9 reasons. First, plaintiffs failed to state a federal racketeer influence and corrupt organization claim. That's the RICO charge. Plaintiff lacks statutory standing to sue under RICO because they have no cognizable property injury and failed to allege racketeering activity that caused any injury. Even assuming plaintiffs had standing, however, the CCAC complaint plainly fails to allege the necessary elements of a civil RICO claim. So basically, if you guys aren't familiar with the case, let me go back. I just jumped right in and was like, if y'all watch my channel, you should know. But basically what happened, or maybe I did go over it. I forgot. A lot of stuff is going on in my brain. But basically, a couple of celebrities were sued for basically promoting this Ethereum Max coin on their social medias, which plaintiffs are alleging resulted in them going to buy the coin, thinking that they were going to make money. And probably at some point they did make money, but at some point, a bunch of people sold it off, and now the coin is basically worth nothing. This cryptocurrency is basically worth nothing, and they lost their money. Now they're trying to blame it on the people that promoted the coins. And Kim Kardashian is basically saying like, hey, we were not in cahoots. You have not proved that we were in cahoots. We are not an organization, all of the things, right? They were basically just doing an endorsement, but they're not necessarily a part of an enterprise, is what Kim Kardashian is saying here. So let's see what else. Second, the plaintiffs who do not reside in California lack standing to assert claims under California law precisely because they do not reside in California and they do not allege suffering any injury in California. All right. Third, plaintiffs fail to state a claim under any of the state consumer statutes because they do not plead threshold requirements necessary to state a claim. Plaintiffs do not allege facts showing that they actually relied on the alleged statements or omissions, and thus they lack statutory standing under the unfair competition law, California consumer legal remedies, or false advertising law. Plaintiffs otherwise failed to allege facts showing that defendants' conduct caused their alleged injuries, and thus they do not state Florida deceptive and unfair trade practices, New York general business law, or New Jersey Consumer Fraud Act. Oh yeah, they're all over the place in all the states, right? Plaintiff failed to state a claim under any of the state consumer statutes because none of the alleged misrepresentations or omissions that plaintiff challenged are actionable. Fifth, plaintiffs failed to state a UCL claim. I keep wanting to say UCLA. UCL claim. Plaintiff's unlawful prong claim fails because they have not stated violations of another law. Plaintiff's unfair prong claim fails because their allegations of unfair conduct are wholly conclusory, do not plausibly demonstrate that any defendant engaged in unfair conduct, and otherwise rely on the same alleged conduct that fails to state an unlawful prong claim. They are coming in at them, but honestly, I'm not familiar enough with, because cryptocurrency is so new, and the way that they promoted it, the arguments that they're making, they make sense, but I would have to see more of what they're talking about to see if you can either, stocks are stocks, but Bitcoin, the value, it's up, it's down. There's really no way to tell what the value is. Let me stop talking about cryptocurrency like I know how the value of cryptocurrency is decided. But let's get back into the complaint. Let's get back into the law, okay? Sixth, plaintiff cannot state a CLRA claim because, as other courts have already held, virtual currency like the EMAX token is not a good or a service within the CLRA meaning. I don't like acronyms. Seventh, plaintiff failed to state a common law aiding and abetting claim because they have not plausibly alleged that defendants committed any civil wrong. Moreover, plaintiffs failed to allege any non-conclusory factual allegation demonstrating that any defendant had actual knowledge of the alleged civil wrongs or substantially assisted in the commission of those wrongs, which would be correct because if they're just being influencer, they got hired for an endorsement deal, they, of course, cannot do unfair trade practices. And actually, Kim Kardashian had a lawsuit for the unfair trade practices. So she should be a little bit more on the lookout, or her attorney should be a little bit more on the lookout whenever she's signing these endorsement contracts, which is what the plaintiffs were basically arguing in their complaint. They're influencers. They do this all the time. They should definitely know whether they're supporting an accurate product, right? Okay, so let's see here. We have 8, the plaintiffs failed to state a common law conspiracy claim because they do not allege that defendants committed an independent civil wrong. Moreover, plaintiffs do not plead specific factual allegations plausibly demonstrating the formation of or agreement to the alleged conspiracy. 9th, plaintiff failed to state a claim for equitable relief. While plaintiffs purport to assert a standalone claim for unjust enrichment, no such claim exists under California law. Plaintiffs' claims for equitable relief are otherwise insufficient because they do not plead that they lack an adequate remedy at law. In sum, the CCAC should be dismissed against all moving defendants. Okay. A lot of words. And then they're going to go into the background of what is even really going on in this case. What is Ethereum Max? What they're alleging that they did wrong. And so let's cover it. So Ethereum Max is going to be referred to as Emax here, is a cryptocurrency project centered around Emax token, a blockchain digital asset. Emax tokens function like other popular digital currencies. They can be traded, spent, otherwise transacted between token holders. The Emax token can be purchased or sold. Oh man, where'd it go? Oh, stop moving. Purchases are sold through online exchange and is primarily traded against the cryptocurrency Ether, the native currency for the Ethereum blockchain network, which is a roughly 190 billion market capitalization at the time of filing. It was created with a vision to bridge the gap between the emergence of community-driven tokens and well-known foundational crypto coins. The Emax token price has fluctuated since its launch due to token holders trading and other external market conditions. Plaintiff alleged that the Emax token price artificially increased because defendants' conduct causing investors to purchase their losing investment at inflated prices. Geez. So basically, since Kim Kardashian, Floyd Mayweather, and I do remember Jake Paul was involved in this case because they had like a boxing fight, and they were like, oh, if you buy your tickets with the Emax coin, then you get invited to this party and you get this and you get that. So they're saying that since the celebrities is like, oh, buy the Emax coin, the price basically went up for that time being. And then all of a sudden, once the celebrities sold or their friends sold, they had inside information, they sold the coin, and then all the regular people lost money. It's basically what they're alleging. And Kim Kardashian and whoever else is filing on this with her is like, no, we didn't do that. We didn't do that on purpose. And they're trying to allege we did it on purpose. The CCAC does not name the corporate entity behind Ethereum Max and the Emax tokens because it is allegedly unknown to plaintiffs. However, upon information and belief, plaintiff alleged Ethereum Max headquarters and principal place of business is in California. The CCAC identifies 5 individual defendants, 4 individual, Justin Maher, Steve Gentile, Giovanni Prone, and Mike Spear are allegedly co-founders / creators of the Ethereum Max who exercise control over Ethereum Max and directed and or authorized directly or indirectly the sale or solicitation of Emax coins to the public. Justin French allegedly served as a consultant and spokesman. Although none of the individual defendants allegedly reside in California, plaintiff alleges that California is the state from which these defendants allege misconduct. The celebrity defendants, apart from the individual defendants, name 5 celebrities: Kim Kardashian, Floyd Mayweather, Paul Pierce, Russell Davis, and Antonio Brown. Okay, I thought it included Jake Paul, but maybe that was a different case because everybody's getting sued for these cryptocurrency scams. So maybe that was a different case. I thought Jake Paul was in here too, but it's Paul Pierce, who allegedly promoted the EMAX token to the public. Kardashian, Mayweather, Pierce, Davis, and Brown are widely known sports and entertainment figures. Plaintiff claimed the individual defendants collaborated and conspired with the celebrity defendants to artificially increase the price of EMAX tokens. For certain celebrity defendants, but not all, the CCAC alleges upon information and belief that they received payment for their alleged promotion. Plaintiffs also allege that the individual defendants were able to and did make similar payments to 5 other celebrity promoters to shield the EMAX coin, but those individuals are not named as defendants. Named plaintiffs are putative class. The 9 named plaintiffs are investors who reside in New York, California, Florida, New Jersey, and allegedly suffer investment losses after purchasing EMAX coins. Plaintiffs make boilerplate and identical allegations they incurred losses. After viewing numerous celebrity endorsements of EMAX, the named plaintiffs do not allege which endorsement they saw, when they saw them, which specific defendant was responsible for the endorsement, and how those endorsements led to their purchase of EMAX coin. Which is true. You have to show, okay, I saw Kim Kardashian's post and it made me buy the coin because Kim Kardashian is the best crypto investor that I ever knew in my life. And since she said that the coin was good, then I thought that the coin was good, so I bought it. But they didn't allege things like that. And that's what they're pointing out. However, they just need to plead facts sufficient enough to state a claim. So do they need to go into detail about which one they saw? Maybe not. But the fact that they named those particular defendants and they said that they saw the post, which resulted in them buying it, they could be on the right track to being able to prove that. But we will see. Of course, the defendants are going to argue in a way that is the most beneficial to them. Okay. They don't allege which endorsements. Plaintiffs do not allege where and when they purchased the EMAX tokens or the amount purchased or whether they even still possess any EMAX tokens. Plaintiffs make no concrete factual allegations about the amount of losses they allegedly suffered. Plaintiffs seek to represent a putative nationwide class of all persons during the class period. During the class period of May 14, 2021 and June 27, 2021. Herein, the relevant period purchased Ethereum Max EMAX tokens were subsequently damaged thereby. Plaintiffs believe that the class consists of at least 100 people. Plaintiff asserts that California substantive law applies to the entire class. Okay, let's see where we are here. All right, and they are going to jump into the argument shortly here, but we are just going to finish up the... Where were we? I done lost it. Oh, that was pretty much it. Okay, so they're basically suing under all of these different statutes, which we're not about to go through. We already went ahead and listed the things that they are saying that they failed to do. Let's read the RICO one. And I think that's what we're going to cover in this one. Because this one is long. This complaint is this answer is very, very long. So, all right, here we go. So, plaintiffs failed to plead a plausible RICO claim. To plead a civil RICO claim based on a pattern of racketeering activities, plaintiff must allege conduct of an enterprise through a pattern of racketeering activity known as predicate acts causing injury to plaintiff's business or property. Rule 9b applies to fraudulent conduct relevant to the alleged common purpose of the enterprise and alleged predicate acts, and thus requires a heightened showing of circumstances and fraudulent acts, including the time, place, specific conducts, and the false false representations, as well as the identities of the parties to the misrepresentation. Does not allow a complaint to merely lump multiple defendants together, but requires plaintiffs to differentiate their allegations to inform each defendant separately of the allegations particular to that defendant alleged participation in the fraud. When a fraud suit involves multiple defendants, a plaintiff must identify the role of each defendant in the alleged fraudulent scheme. Plaintiffs do not plausibly allege elements of a civil RICO and fail to meet the 9B requirements. So that is what they're alleging here. So we have a case where they're suing for cryptocurrency, buying the cryptocurrency because the celebrities promoted it. But what Kim Kardashian is arguing is that you guys haven't really told us which promotion you saw. Technically, they did list different promotions, but they just didn't name each individual one, which could possibly come out of discovery. But I get what they're saying. It's hard to defend against if they don't know how many people actually relied on my post and how many people actually relied on Mayweather's post and things like that. So I see why they're contesting it, but it seems like it's going to be a pretty long time to get to this. They're going to have a hearing on October 17th. So it'll be very interesting to figure out what the court is going to say as far as this motion to dismiss. There were several other motions to dismiss filed, but I didn't look at all of them because it was too many and I wasn't about to buy all of those. So it's okay. All right. We have Hella Swanky saying, hey, Bri, hi. I hope everyone is well. I think everyone is well. How are you guys doing? Hella Swanky says, driving, so no chatting for me, but I'm listening. Very curious about this Meg Thee Stallion sitch. Did I miss it? Yes, you did miss Megan Thee Stallion. My computer is telling me that my Wi-Fi is bad right now. So I'm hoping that you guys can still hear me. But yeah, we covered Megan Thee Stallion first. We probably should have covered that case second because this Kim Kardashian one is pretty uneventful. It's just giving us a bunch of case law and rules, but I didn't have time to look over it before going live today. So at least we got what she said. They're just moving to dismiss the claim. I will keep an eye on it for October 17th to see if they actually have their hearing or the judge makes their decision. I do see why they are objecting to this case. Megan Thee Stallion, that case was a little bit more feisty because we got to listen to some music and see if they were pretty similar. And I think the general consensus was, well, you can go back and watch it and then you can see what the general consensus was. And you can also give your opinion on whether you thought it was similar or not. So Slinky also says, oh, dang. Okay, no worries. I'll catch the replay. Okay, yeah, catch the replay. The Kim Kardashian one, like I said, pretty uneventful. I don't know what cases we are going to cover next week, but I do have to get back to prepping for my trial for tomorrow. And I'm really hoping that that thing goes forward because I want it to disappear out of my life. I want it to be done with. I want to go ahead and win this trial and try to win this trial and get it off of my desk so that I can get on to some other cases that I have going on. So, got to prep for a trial for tomorrow. So this was a little bit of a shorter live stream for those of you that popped in late. Sorry that Kim Kardashian wasn't more eventful. I thought it was going to be more eventful. I thought they were going to be like, we didn't post that, but they couldn't really say that because there was evidence that they posted it. So, yeah, that was the end of the live stream for today. I'm not reading all those words on that page and all the legal, what do you call it? The statutes that they put on there. I'm not going through all of that. So if you guys are interested in seeing that, let me know and I can share a link to you to see if you want to see everything in that complaint. Mr. CKB says, I'm sure you'll do great. Yeah, I have a good feeling about it. I hope it goes well. I will let you guys know next week if it goes well or not. I'm just hoping that they don't continue it. I hate that. I put a lot of effort into this case this week, so it better go forward tomorrow. I do not want to continue it. Okay, but I'm not going to agree to it continuing. So They better be ready. All right. So thank you guys for joining on the live stream. We will be back on Tuesday next week covering whatever case comes out over the weekend, because you know a lot of stuff be going on. I might do some tweets. I probably should start tweeting a little bit more. Let me know if you guys want to cover the Marilyn Manson case. I know a lot of people have been covering it. It's just so much going on, and I'm like working full time in my own law firm, so I don't really have time to go through all the things to give you an organized live stream. But do let me know if you guys want to go into Marilyn Manson. We did cover the complaint on this channel, and we got some pretty good traction on that video. But we covered the complaint. But there has been more things filed, motions to dismiss, all not motions to dismiss, but anti-slap motions. Let me know if you guys are interested in that. I will see you on the next live stream on Tuesday. And then next Thursday, we may be on someone else's channel. So I will let you know on Tuesday if we're going over to someone else's channel on Thursday. So we will probably, if we do the other channel on Thursday, we won't have a live stream on this channel on Thursday. So I would definitely let you guys know on Tuesday if we're doing that. If not, we'll be here on Tuesday and Thursday next week, and I will see you guys in the next live stream.